Good morning or good afternoon, everyone. My name is Erin Page, and I'm the Senior Law Librarian on staff with Fast Case Legal Research. Thank you so much for joining us for today's presentation. This is going to be the 8th episode in our series, Litigation in Light of COVID-19, and today's topic is managing a trademark portfolio during COVID-19. Just a couple of quick announcements before we begin. First, you may have noticed that you are currently in listen-only mode. This is to cut down on the amount of background noise so that everyone can hear today's presentation. However, you are still welcome to ask questions during the presentation. To ask questions, please use the questions button on your GoToWebinar pop-up. Those questions will be moderated and we will do our best to address them during the presentation. Second announcement. Today's session is not intended for CLE credit. It is a great informational source about the current status of the law. And if you have any questions about that, please feel free to reach out to us and we'll explain further. All right, so with that fun introduction, I'm going to turn it over to our presenters. Michael Sander is the founder and managing director of Docket Alarm, and he's going to introduce our guests today. Michael?
Thank you very much, Erin. Thank you all for joining. For those who are unfamiliar with this webinar series, for the past 8 episodes, we've been going over various litigation topics in light of COVID-19. Obviously, COVID-19 has affected pretty much every aspect of litigation, every aspect of really our society. So we're kind of really going topic by topic. And this week, we're really digging deep into trademarks. Some of our previous episodes actually touched a little bit on trademarks, but today we really want to focus entirely just on trademark law, trademark prosecution, trademark litigation, and a variety of interesting topics concerning trademarks. So today we have actually 2 great guest speakers who are actually going to help kind of bring us through what's going on in trademark law in light of COVID-19, both on the litigation side and on the prosecution side. Our speaker, Meredith Williams, she is an attorney at Rutan and Tucker, focusing on representing and advising clients and protecting their intellectual property rights. Her practice emphasizes trademark and copyright litigation, trade secret misappropriation, false advertising, and unfair competition. And she advises clients on how to best promote and defend their brands and other IP assets, given novel legal issues raised by social media and advances in technology. Her experience representing both plaintiffs and defendants in federal state court, in ex parte and inter parte proceedings before the USPTO and the Trademark Trial and Appeal Board, and also in domain name disputes and other takedown procedures. These collective experiences give Meredith a variety of tools to assist clients in both enforcing and defending her rights. And I'll also add that the way I found Meredith to try to speak to this is she wasn't just a random trademark attorney out there. We actually pulled down the top 10 Trademark Trial and Appeal Board opposers, and she's within the top 10 for 2020. So she files far more trademark oppositions than pretty much the vast majority of attorneys in the United States. So she's really very highly qualified to talk on this subject. Our second speaker is Nehal Madhani. He's an attorney and the founder and the CEO of AltLegal. As an attorney at Kirkland & Ellis, Nehal felt inspired to make legal practice more efficient. He taught himself programming, and he founded AltLegal, a company whose cloud-based IP docketing software helps legal professionals prepare and manage hundreds of thousands of IP filings and deadlines daily. Nehal is a JD from UPenn and a certificate in business and public policy from Wharton, and is an undergrad from Northwestern. And Nehal really brings in quite a bit of experience on kind of the prosecution and docketing side, and his company basically manages on behalf of his attorney clients thousands of trademarks across the country. So he really can speak to what many trademark prosecutors are doing across the country and the different types of ways that their practice have been affected by COVID-19. So I kind of wanted to start off with a few topics. This is not going to be a very slide-heavy talk. I think we really wanted to just jump into the speakers. And our first kind of topic to discuss was really about some of the interesting trademarks. We kind of wanted to start off a little bit fun and just talk about some of the trademarks that are actually being filed related to COVID-19. We pulled up, basically, this is just a quick chart showing you every single trademark that's been filed that either mentions coronavirus or COVID-19. Nehal, can you tell us a little bit about what's going on out there? What type of marks are being filed, and what's really going on before for trademark prosecutors and the types of marks that are being attempted to be registered?
Sure. So I think, this isn't that different from, what we see every time there's some sort of pop culture event or, some sort of global event, right? You're going to see a surge in trademarks, people thinking that if they go out there first and file this trademark, they're going to get it, right? I think Trump had a misspelled tweet and there were dozens of trademarks filing around that. So it's not that different from that, but what we are seeing is a global phenomenon and global crisis at the same time where folks are just trying to capitalize on this. So there've definitely been some fun trademarks along the way with folks seeking trademarks that they're most likely not going to get. So there's COVID-19 compliant, which is for real estate agency services. I'm not quite sure how that follows. Some of the more fun ones are COVID-19 sucks. We shall never forget 2020. And I think what you see is most of these applications, the vast majority, are certainly pro se applicants that are seeking to go in and, thinking that if they file this trademark, they're going to get exclusive rights and make all the money from the word COVID-19, which is flawed in itself. But, I think the real problem is most of these are obviously not in use. They're almost all filed as 1B applications at this point. And then you get really flawed specimens like this one here, where this gentleman who has a YouTube channel literally is trying to get, I think, filed 4 or 5 trademarks, spent close to 2,000 hours with the PTO just to put his face on a t-shirt along with coronavirus or COVID-19. And obviously it's not really a source identifier. So you're going to see a lot of office actions issued. I've also heard from some folks that the PTO is actually routing a lot of these applications to a single law office or a single set of examiners. So I think you're going to see more standardization around this. So there are a few interesting ones that are actually legit. One is COVID Carrot, which I think is an application to a software application to manage COVID crisis. Bloomberg itself has filed a few applications around the COVID crisis. So one is COVID Job Corps. The other one is Fight COVID Corps, which is to just provide financial, operational, and educational assistance to state and local agencies. So certainly more of a bona fide intent to use than I think this gentleman and his t-shirt.
Right.
So,
and I think you also mentioned there was some others like Seaface, which is actually filed by a legitimate company, Royal Caribbean Cruise Lines.
That's right. So we are seeing interesting use cases around these trademarks as well. So Seaface was filed by Royal Caribbean. It's a 1B application right now, but filed in Class 10 for sanitary mask for virus isolation purposes. So I think obviously with, a lot of governments mandating the use of face masks, we're going to see more of this. We're going to also see, we've also seen this in the news, right? Some clothing companies repurpose a lot of their excess capacity right now and start making face masks. Right. You've also seen other companies just use this in part as a branding opportunity. So Disney has started creating their own face mask with all of the Star Wars characters and making them in part for kids who need smaller face masks. So
Meredith, I assume these are not your typical clients. I assume you're not representing this client here in front of the USPTO.
No, not typically. It is interesting when Nehal mentions, this doesn't serve as a source identifier. I think a lot of people tend to think of trademark as almost like a land grab. If you get this word, if you start, if you are the first to file an application and get a trademark word, then you will somehow own the word. But it really does not work that way in trademark law. You need to actually use a mark and use it in a manner that is source identifying. So a lot of the other sort of faulty marks you see tend to be on apparel or class 25 goods, when people just sort of slap a phrase on a t-shirt in a way that's more decorative or ornamental. That's not going to serve a source identifying purpose, as well as if you have sort of very common phrase, then that's also not going to be able to serve as a source identifier, and those will get rejected by the Patent and Trademark Office. But we do have clients who are using marks already for a clothing brand and apparel brand, and that are then expanding from apparel to masks, sort of going from those class 25 goods to class 10 or class 11, class 9 goods. So there are some opportunities to expand and take a mark that you're already using as a source identifier and to shift into other product lines like the face masks.
Yeah, so these Disney marks definitely seem kind of a good example of that. So moving on a little bit, kind of going a little bit further, Meredith, can you tell us just a little bit on what's going on? There was a big package that was passed recently called the CARES Act. Can you tell us just a little bit about what the CARES Act is and specifically how that is affecting trademark prosecution today?
Sure. So the CARES Act has actually empowered various government agencies, in particular the U.S. Patent and Trademark Office, to sort of go beyond the regular statutory deadlines and to give relief beyond the typical statutory deadlines. So when you're prosecuting a trademark, you have certain filing deadlines with the trademark office. If they, for example, give you an office action saying there's some issue with your trademark, that it's not going to be able to register, you typically have 6 months to respond to that. But the USPTO's CARES Act relief allows an applicant who had to respond to an office action anytime between March 27th and May 31st, 2020. It allows you to, if you sort of miss your deadline in that window, to file a statement with the trademark office and say, for XYZ reasons related to COVID-19, we were not able to get this filing on, and then the USPTO will accept your filing even though it's a bit late. And so in addition to office action responses, applicants who have a statement of use due are able to take advantage of this statutory relief. Anyone who is filing an affidavit of excusable non-use, a renewal application, those sorts of things. And even in prosecution, not just in prosecution proceedings, but also in inter-parties proceedings where you have someone trying to block someone else's trademark, saying that it's confusingly similar or whatever other issues they have with it, your deadlines to file that notice of opposition have also been extended. And it's not automatic. You have to request it and you have to state, sort of fact specific to why you deserve that relief. But the trademark office is giving that relief through the CARES Act.
Got it. And are you seeing a lot of clients actually filing for this relief? And how's that proceeding?
We haven't had too many prosecution clients need it at this point. We have had in our opposition proceedings some of the other parties requesting extensions of time, and we might actually today, for one client, request an extension of time. It is difficult, right? Even if you're sort of on the verge of settling a matter or sort of trying to sort things out, you may not be able to get sort of everything you need, paperwork you need together in time. So we are taking advantage of that, and we're seeing other parties take advantage of that as well. You really just have to meet the board standard. This is what's showing right now is a section from the TBMP. It's sort of the overall procedural manual for Trademark Trial and Appeal Board proceedings. And you really just have to meet the standard that you didn't miss the deadline because of some sort of, delay or lack of diligence on your part.
Got it. And your clients have not been filing these so much. Is that because, or actually, I'm sorry, Nehal, have you seen these being filed quite a bit? Are there your clients, attorneys that work on your platform, or otherwise?
Yeah, so from the attorneys that work on our platform, we didn't roll this out as a blanket update to automatically extend deadlines for the practitioners. So part of it has been because there is still a statement that's required for you to affirmatively say that, this filing delay was because of COVID, right? Whether that's because of your office being closed, cash flow, you couldn't get the files or the specimens or the materials, travel delays, illnesses, whatever, but it has to materially impact. So I would say less than 5% of our customer base has even taken advantage of this. And the ones that haven't done it on a blanket basis. For the most part, they've just done it client by client. Clients are experiencing, issues because of COVID. They've done that. The other interesting thing is the PTO is also waiving any petition to revive fees or reinstatement fees as well during this time. So
okay, but let's just actually slow down there just a bit. So just so the folks on the call understand,
yeah,
what is it exactly that you do, and how are you helping prosecutors right now? That's
sure.
what does AltLegal do, and if you can just tell
Yeah.
us a little bit how how this plays into filing these extensions for time and so forth.
Sure. So as taking a step back, what AltLegal does is it provides software to law firms and corporate legal departments to create and manage their trademark portfolio. So one aspect of that is, say, for the US PTO, we will automatically bring in all of a particular client's filings, automatically update them, and calculate the deadlines for them.
Mm-hmm.
So in part, what we've by default are doing right now is still giving the actual deadlines without the impact of the CARES Act because of that statement requirement. So for the most part, our customers are saying, keep our docket as is. There are a handful of customers that, had to make bulk edits, to specific clients' portfolio and say, look, because of COVID, go out and extend these deadlines by the applicable deadline, which is now June 1st. So for the most part, I would say, again, most people are not taking advantage of this yet because they have a need to, and hopefully you're not running right up against the deadline.
Right, but the idea is if a number of their marks are running up against a deadline, they can kind of select a bunch of them,
Exactly.
try to get the extensions kind of in bulk rather than
Exactly.
file
So
each one
go into each one and say 6-1, they can just go in and through our software and just make it all 6-1 as opposed to what it was before.
Got it. And so Meredith, I think there's a few requirements in this statement. Are these very specific requirements, or is it kind of more a I think I read that there was, you have to say that, there was some office closures or there was cash flow interruptions, et cetera. Are these like specific, statutory based reasons for getting an extension, or is this something kind of more of a holistic factor test that has to be that the PTO takes into account?
It would be more of a holistic factor test. The PTO is really just looking that people are sort of submitting a sensible factual scenario. It's pretty wide open. In addition to those specific instances that you mentioned, sort of travel delays, personal or family illness, or similar circumstances. The or similar circumstances is going to be pretty broad and allow for some flexibility there. The one deadline I noticed that does not appear to have been moved, and it sort of makes sense given how long of a time frame it is the 5-year deadline after a mark has registered to file a cancellation. So when a mark is published, you have an application is published for opposition, you have 30 days to oppose. That's a very tight window. So it makes sense that the USPTO has given people more time on that. But if a mark has been registered already, you would file a cancellation proceeding against that mark, and you have to do that within 5 years. It doesn't look like the CARES Act has extended that deadline, which makes sense since it's a much longer time horizon.
Right. So I mean, I think it's important to note that while extensions are being granted pretty liberally, it's not, you don't get no one gets automatic extensions when they're filing for trademarks. It's something that you kind of have to make, affirmatively go out there and get the extension. And some of these can be somewhat, they can be strict too. If you miss the deadline, there can be some serious consequences to it. Is that correct?
Definitely. If you miss your window to oppose, even though technically a cancellation proceeding where you're looking to cancel a registration as opposed to oppose a mark from registering in the first place, it's the same standard of likelihood of confusion and priority. It's the same law at issue, but once an applicant has registered a mark and has a registration certificate in hand, you can imagine that applicant registrant is going to be much more protective of their rights. So if you need to be monitoring applications that are proceeding to registration for potentially confusingly similar marks and oppose those from the get-go. And one instance that we've noticed, and I imagine AltLegal and IP docket tracking is really important here, is when a party has filed an intent to use application, it's not always as obvious when that intent to use applicant has filed a statement of use, and that starts your clock for opposing. So those are sort of important deadlines to keep on top of.
Got it. Meredith, have you seen anyone, I don't want to say abuse, but kind of try to take these extensions and try to get a little bit more than they otherwise would be justified? Is any of this going on? Or this could be a question for both of you, but I'll start with you, Meredith.
Yeah, we have seen, you know, at least in one of our proceedings, the respondent had not been responsive for months, for over a year before we filed a motion to compel, and so that respondent sort of filing oh well, you know, COVID-19, there's been disruption, more general statement seems a little bit less credulous, but for the most part, I think people are only taking advantage of it in terms of they have actual disruptions and difficulties with getting responses from their client or getting materials together at this time, given people are more focused on the business disruption. So even for our office, even in the instance where we feel like they're sort of taking advantage of the circumstances, at the same time, you know, you want to come across as the party that's being reasonable and sensible. We don't tend to oppose those unless the circumstances are really egregious.
Got it. So we you kind of you'll wait and see what the USPTO does there.
Right.
You're not aware of any, you know, particular opinions that have come down hard on one side or the other for making, you know, trying to claim a little bit more than they could otherwise?
Well, I mean, yeah, we had in one action, a party had asked us for a 30-day extension. We gave the 30-day extension. Then they asked for a 90-day extension. You know, we kind of wanted to see where we were in 30 days. They had an unconsented motion with the board for that 90-day extension, and the board just recently granted it. So I think the board is typically pretty liberal on motions to extend generally, and in these circumstances is, I think, rightly giving parties a little bit more flexibility.
Yeah, and I think, you know, in our previous episodes, we talked quite a bit about extensions and timing of hearings and a variety of other, you know, legal deadlines. And it really does also depend on the nature of what's actually happening. You know, COVID is a very fluid, you know, it's what's going on in the world. It's changing every single day. So we actually found in a previous episode, we actually were talking about how there was a motion for an extension of time that was originally denied by the court. And then 2 weeks later, there was a renewed motion for an extension of time. And exactly, I think it was a hearing that was coming up, or maybe it was a papers leading up to that hearing, and they asked for it again. And 2 weeks later, the judge granted exactly the same motion. For the first one, when he denied it, he wrote this like 5-page opinion why you know it should be denied, and COVID-19 is not bad enough yet. This case was in Texas, of course. And then, you know, the next 2 weeks later, he said, all right, enough's enough. You know, the motion for extension granted. Nehal, can you talk to, I know you have clients kind of all over the world. I mean, and can you talk to us a little bit about that on the international side? So in the US, yes, you know, you can get extensions, you can put things off relatively liberally. What's going on in the European Union or, you know, Canada? WIPO rules, that sort of thing.
Sure. You know, I think what we've seen is that a lot of other jurisdictions, I think, are a little bit more flexible with these deadlines. So, for example, take the EU IPO. What they've done is that they said, look, any procedural deadline, we've just gone out and extended it. You don't necessarily need a statement. Take, in contrast to that, Australia, where, you know, we haven't given you an automatic extension, but literally just go on our site. You don't even need a written explanation to say that you need more time, and we'll give you up to 3 months. And so with Canada, they've kind of taken the same sort of approach as the EU, where there's extending deadlines. So I think, you know, what we've seen is a statement requirement. I don't know if it's sort of necessary, especially given how broad, you know, that mandate is, as Meredith mentioned, right, is or similar circumstances. So, you know, I think what we've seen from Europe, Canada, and even Australia, I think is probably a better approach, just to give folks more time if they need it, without necessarily adding the pressure of, you know, the statement, right, which does become part of the application. And I doubt this is going to really materialize, but, you know, could there be an argument that someone could look up that statement, seek to try and prove or disprove whether you actually needed that extension, whether it was related to COVID circumstances, and claim fraud? It's much more attenuated, and Meredith can probably speak to the elements of fraud there. But I think, you know, why add that extra burden if you don't need to?
So just so we're clear, so, you know, in the US, you required to write this statement that you've been affected by COVID.
Right.
And the issue is, you know, if you write that, hey, my office was closed when it really wasn't, then that's fraud on the patent office, and it can lead to a number of problems. Is that kind of what you're
right? I'm saying that's a little bit more of attenuated, I think, circumstance. It could, but, you know, Meredith, have you dealt with some fraud cases, and what are the elements there?
Yeah, it's actually a very difficult standard to meet. You need not just a material false representation of fact to the USPTO, but you actually need intent to deceive. So you can imagine it's probably already difficult enough to, in discovery, get evidence of someone, knowingly making a false material statement to the USPTO. But then, in addition, having the burden of proving fraud with clear and convincing evidence, and proving that intent to deceive, it's very difficult to get inside someone's head and say, they were intending to deceive the USPTO.
Right, and I think the evidence collection here, obviously, it's just people. We should give folks a benefit of the doubt, especially under this set of circumstances.
Definitely.
So
one area I would say people should be cautious about is making false statements of use, because while the Trademark Trial and Appeal Board has ruled, that a party, even though they made a material false statement, that wasn't enough for fraud, they've also in other circumstances said that, there's nothing that excuses you from not having the mark in use. So non-use can be a problem. If you have an application that's your own or your clients or your friends, and they're looking to, get their mark as soon as possible, make sure you don't sort of make any false statement of use, because non-use at the time of a statement of use, that will invalidate your mark no matter what your intent was.
Got it. So this is actually identifying a pretty nice potential pitfall to avoid. I think we want to get too closer to the pitfalls. We actually we're going to discuss all the different types of pitfalls that can happen coming up during COVID-19. But just to kind of go back to the international side of things, Nehal or Meredith, Nehal, do you have any insight on why some of these countries have kind of not required this statement of use? The statement that COVID-19 is affecting the prosecution, or is it kind of just each country did its own thing, and this is kind of where the chips fell?
Right, I think a lot of it is just each country did its own thing, and and what we're seeing is just updates regularly. There's actually one publication that has put out a great resource if you're looking at international coverage. It's World Trademark Review, worldtrademarkreview.com. They have made this section of their website actually available for free, where you can see all of the countries and the changes they're making. But Michael, to kind of answer the question, it's literally just each country and each IP office is making ad hoc decisions based on what they think is fair.
Got it. All right, so let's move on to kind of the major pitfalls to avoid. And I believe we're starting off with, and by the way, I just had up on the screen there, this is the CARES Act for trademark applicants. It kind of specifies what types of things can get actually delayed and how to do so. So Meredith, I'll start with you. What are the types of pandemic-related pitfalls that one should seek to avoid, if any?
Sure. So I mentioned, filing a false statement of use. Definitely want to avoid that. Just, you have the option to get an extension. Just get an extension if you need it. False specimens, false statements of use. I mean, in general, it's just a good idea to avoid price gouging and fraud. It's been up in the news a lot. And actually, the FTC and the FDA have sent over 7 letters now, I think, cease and desist letters to companies that were making sort of false claims about their products, or their products treating COVID-19, preventing COVID-19. There was one company that was selling tea and other essential oils. Another one was selling a colloidal silver as a dietary supplement, saying it helps with COVID-19. And the FTC, FDA letters had some potential real teeth to them, saying if the companies didn't cease and desist within 48 hours, they're going to get an injunction and maybe have to refund each and every one of their customers. So, in general, it's a good idea to avoid price gouging and fraud, but I think that the state and federal agencies, attorneys general, are really looking out for those issues and looking to put a stop to them using, either federal false advertising law or the states that have price gouging laws. I know at least California, Washington, and New York have pretty strong anti-price gouging statutes.
Right, and I think you pointed me earlier to, is this the same? I think we'll get into the price gouging pretty soon. You pointed me to this one case, Syndicators. Can you tell me a little bit about what's going on in here?
Let me see. Sorry, I don't have that one up.
Oh, you don't have that one up. Okay. think it was Syndicators and Shotus. These are two recent TTAB opinions.
Oh, yes.
Sure.
Yeah, so those are the non-use issues. It really shows the board. Let me see. Yeah, these opinions really show the board looking at a party's use or non-use. If an opposer makes a prima facie case of, hey, this person wasn't using the mark, and what qualifies as use in commerce varies depending on your goods here. The Shada's opinion, they're looking at distribution of some T-shirts, some hats, and some shorts in Miami, Florida. That's not going to be enough. So it's really the pitfall to avoid is one of your typical pitfalls, but it's more important during COVID-19 just because it's going to be more difficult maybe to get your goods and services out. But you want to make sure you consult with a lawyer about, is your use going to qualify as use in commerce? I think a lot of people have some misunderstandings about that. We've opposed marks, where someone claimed that they used a mark in commerce in the US because they're using it in another country. There's a lot of confusion about what counts as use in commerce, and it's something that you want to be very careful to make sure you're actually having, interstate commerce that's going to count.
Got it. So moving on, you mentioned price gouging, and I know that recently we read in the news about a case, or maybe it was a series of cases involving 3M. Can you talk to us a little bit about this, Meredith, and just kind of walk us through what's happening in this case and what are the main issues at play here?
Yeah, so it's a really interesting sort of litigation campaign by 3M, and one that I think is interesting for a number of reasons. On a PR basis, it's really a brilliant piece of PR. You read this and it's they're talking about sort of the healthcare workers on the front lines and how our company is looking to support them, and then there's these unscrupulous wrongdoers out there who are engaging in all these price gouging schemes. Whereas I think they put it bold and underline, what 3M has not done is increase its prices, right? So nice. really drawing the line between us and them, the good guys, the bad guys. And even, I think they even say one of these complaints that they're gonna donate any of the damages they recover to COVID-19 relief. So it's a really brilliant piece of PR on that level. Sort of looking at the legal claims, stepping back a little bit, I think a lot of commentary has looked at these cases and said, well, can you use trademark law to fight price gouging? And I think one of the more difficult scenarios to get a trademark law to reach would be where someone is selling your legitimate goods and just selling the goods. That's all they're doing. They're not sort of making any claim to be associated or related with you. That is something where you would need to rely on state price gouging law rather than trademark law. I think the particular complaint I was looking at was the one against Performance Supply LLC. That's one in which this company apparently actually sent a letter to sort of the New York procurement office that really makes it sound like they are 3M. They said, due to the national emergency, acceptance of the purchase order is at the full discretion of 3M and supplies are based upon availability. Overseas, the N95 mask, 3M can begin shipping in 2 to 4 weeks, et cetera, et cetera. Essentially just acting like a complete authorized distributor of 3M. And when you have people creating that false association, that is going to fall under the Lanham Act and be really easy to sort of punish and go after. There's sort of two prongs to the Lanham Act Section 43 claims. One is false advertising and one is false association. I think this kind of conduct really hits both.
Got it. And actually, this is another exhibit. I think this is from the Texas case, or one of the Texas cases actually, where I think one of the distributors actually, their name of the distribution company was called 3M Company Trust Account. And they have absolutely nothing, I mean, other than buying and selling 3M's equipment, they don't really have much to do with 3M. Yeah, that can definitely trigger some of those Lanham Act violations. Talk a little bit about first sale doctrine and what is first sale doctrine, because these do seem like relatively tough cases for 3M to win. And so my understanding is that the doctrine called first sale prevents people from really suing somebody from selling their product if it's done legitimately. Can you kind of tell us a little bit about the contours there and what, first of all, what is the first sale doctrine? and how does it affect these types of lawsuits?
Right. So first sale doctrine or exhaustion doctrine is essentially when a trademark owner puts a trademark product into the stream of commerce, someone resells legitimate product, it's not going to be, the trademark owner doesn't have control over downstream sales after that first sale. And so the reason for that is the real core and heart of trademark law is likelihood of confusion. And if someone is, someone has a 3M mask and sells it, they're not creating confusion over where that mask comes from. So for these cases, I think the real meaty core of the complaint, the strongest aspect of the complaint is that false association or creating a false impression that the seller is an actual authorized distributor. And sort of the easiest way to draw the line there between where a trademark owner can and can't control the further downstream sales is really is the seller creating a false impression of an association with the companies, because that's really the core of trademark law is acting as a source identifier. So one example I think we had in there was this advertisement in a case.
Yeah, let me pull it up.
About the vacuum sales. Yeah, so the owner of the Kirby trademark brought a lawsuit against this House of Vacuums company, right, and said, oh, they're using our trademark. They can't do this. It's against the law. It's trademark infringement. But if you look at that picture, you almost can't even see where the Kirby mark is, right? Like it's not really saying this is Kirby Vacuums or House of Kirby Vacuums. It's really just legitimately representing that this is a retailer that sells Kirby Vacuums. And so in that case, the court looked at it and said, look, House of Vacuum sells new Kirby vacuum cleaners. That's actually legitimately what they're doing. They may use the Kirby mark to advertise that fact, so long as the advertisement does not suggest affiliation with or endorsement by the owner of the Kirby mark, Scott Fetzer. So it really comes down to, are you using the trademark in a confusing way, in an unauthorized way to suggest that you are a salesperson? And there's been a lot of cases on this. I think Volkswagen has brought a lot of these. It's something like Beetle Barn, referring to your Volkswagen servicer as a Beetle Barn, that was found to be trademark infringement. Whereas just saying, this is a service parts place for Volkswagen cars, that's not going to be unauthorized use. That's actually just truthful advertising.
Got it, because Beetle Barn kind of implies some sort of endorsement maybe from Volkswagen, right, or some affiliation. And exactly. Likewise, if we go back to at least this one case here, this email, I think this is being sent from the seller of the 3M masks. The very fact that they're saying 3M company trust account maybe implies much more of an affiliation than would be otherwise allowed under the first sale doctrine or exhaustion doctrine.
Exactly.
Great. Meredith, you had, I think, kind of wrapping up here a little bit. We definitely want to go to questions, but you had this one really nice quote. I kind of want to kind of wrap up a little bit of these first sale of what first sale doctrine is, and kind of how this actually speaks to quite a bit of the different topics that we were discussing, from trying to grab trademark space as if it's a land grab. So here's a quote from 1924, Justice Holmes, and he says, "What new rights does a trademark actually confer? It does not confer a right to prohibit the use of the words or words. It is not a copyright. A trademark only gives the right to prohibit the use of it so far as to protect the owner's the owner's goodwill against the sale of another's product as his. When the mark is used in a way that does not deceive the public, we see no such sanctity in the word as to prevent its being used to tell the truth. It is not taboo." Meredith, can you go through and tell us, what is Justice Holmes saying here? Break this down into modern 2020 English for us.
Yeah, so I love this quote. It's essentially, a trademark isn't magic. Trademark's not taboo. You can't take a word and say no one else is allowed to use that word. Where trademarks are a very powerful tool is when someone has used a trademark and built up goodwill in a trademark used with goods or services, they can prevent confusing use of similar marks to that. So when someone builds up a brand like 3M. They associate their goods with, sort of particular high quality goods, and sort of also sort of sales in a way that's conscionable and a part of the company's, sort of broader goodwill. Another company can't come in and use that mark in a confusing similar way, either by putting together counterfeit products or in a way that's going to confuse consumers. Really, the heart of trademark law is consumer confusion and preventing consumer confusion. So when someone is using a mark in a way that is not confusing to describe their products, that's, a car dealership services Nissans or Fords or Volkswagens or whatever it is, those non-confusing uses, often called fair use, are not going to be punishable by trademark law. So to me, really, this sort of 1924 quote comes down to the fact that the core of trademark law is about preventing consumer confusion. It's about protecting your goodwill. And while it's a very powerful tool and can be used to, sort of shut down infringement, including with remedies, like taking all of the defendant's profits, getting an injunction, all of those things, it's not magic in the sense that it's not like, as we saw with the sort of COVID marks that Nehal brought up earlier, it's not magic in terms of you get that word and then can prevent other people from using it.
Got it. Thanks very much for this. I just want to kind of recap what we went over today. One, we kind of just showed some kind of interesting fun marks that are coming out of here and the pitfalls that they kind of bring about. Number two, we kind of went over all the extensions of time that are being granted, kind of not quite as a matter of course in trademark prosecution, but relatively easy to get, but not automatic compared to some other countries where it might be completely automatic. And then we also talked about the significant pitfalls that you can fall into, misfiling intent to use applications, or just making sure that your use is actually bona fide and legitimate, and some of these interesting cases like the 3M case. Before we close out, I definitely want to go to questions. Erin, can you are there any questions that have been posted to the chat? I'm not sure if I can quite see it.
Hi, Michael. Not too many questions this time. So the one question that did come up, or that has been coming up, can you speak to any issues regarding injunctions or any of the fairness of injunctions that are extended due to COVID-19 delays? So is there anything that either the presenters see as a complication of a more extensive or a longer lasting injunction or injunctive relief as a result of the COVID-19 in the world of trademarks?
Yeah, so I
go ahead, Meredith. Yeah.
Oh no, I'm not sure exactly which form of injunctive relief the question's getting at. Erin, maybe let me know if there's any other detail on that. But in terms of granting injunctive relief against trademark infringement, it's always an extreme form of relief, and it's often a very difficult form of relief to get. But I would think in the 3M case, it might be one of the easier ones to get an injunction against sort of very clearly misrepresenting, a seller as an authorized seller of those products. But yeah, injunctive relief is always, it's a high burden to get. It's difficult to get. You always want to talk with your clients about what your objectives are in a litigation sort of proceeding, but we typically don't go for an injunction unless there's some really unconscionable and really bad conduct that needs to be stopped immediately, because that's the only way you're going to get a court to grant that relief.
Right. Actually, on the planning call, we even discussed raids. Right. I think in trademark law, it's not uncommon to actually go on raids and seize, a bunch of counterfeit goods or infringing goods. I'm not sure if that's technically a, injunctive relief. Maybe would a raid count as an injunctive relief, or is that kind of something a little different?
It depends. I think you can get authorization to do a raid. You can get different orders and sort of work with the Customs and Border Patrol. I think a lot of what we're seeing right now is because e-commerce has expanded so much. We're seeing a lot of companies shift their focus to online monitoring and enforcement, and that's something that I think is going to be increasingly important. One sort of comment, it would be, rather than going for a full-fledged lawsuit and injunction, which can take a significant amount of time, there's some uncertainty there. using the resources you have in terms of shutting down third-party sellers or using third-party websites to do takedown procedures. You know, you can go through Amazon, Etsy, basically all of the major sellers out there have IP proceedings, sort of informal IP procedures where you can do takedown requests. Taking advantage of those and using your online monitoring and enforcement is really important right now more than ever.
Got it. Meredith, do you do any of this online monitoring, or is that kind of something that a consultancy would kind of handle, and then you kind of take the legal side?
It's something that, yeah, it's something that we can advise our clients on. I think a lot of clients tend to do it themselves in terms of sort of setting up a monitoring and enforcement. Usually where you'd want to get sort of your outside attorneys involved would be maybe to set up that sort of monitoring and enforcement program. And then if you had a UDRP proceeding or a proceeding where you're looking to actually take down a domain name that's set up, you know, sort of to pirate off of yours, which that's sort of its whole other interesting area. But if you see sort of a pirate website, you can do a UDRP proceeding. In terms of doing takedown procedures on third-party sites, that's something that usually people can handle themselves once you are familiar with the process and set up that sort of monitoring.
Got it. Nehal, I take it your product focuses more on the prosecution side, so you wouldn't be so much on this enforcement side. Is that right?
Not as much. You know, we have customers that use other, you know, domain monitoring tools and just generally monitoring tools for, you know, infringements, but not as much for us.
Got it. I actually worked on this a little bit back when I was a litigator. I did takedown notices for a semiconductor company that's where they were basically afraid of imports of fraudulent semiconductors, and it's very difficult to prove sometimes whether a chip is fraudulent or not, but you can at least get the websites to stop using the marks on their websites, which does something. So this is all, you know, there's the two sides here, the enforcement side and the prosecution side. COVID-19 is changing both of those. So this is all pretty interesting. I would like to, Aaron, are there any other questions, or is that,
yes,
was that
there
the
are two
main one?
more questions.
Oh, two more questions. Okay, great.
Yeah, are there any best practices for putting infringers on notice during the current situation when most state courts are closed? Anything that can be done while there's not the traditional route?
Yeah, it is. That's the difficult thing right now is all cases really are having hearings delayed, are having, it's more difficult to get in front of a judge. I think the most effective way to put infringers on notice is to really, if you want to have a lot of teeth in it, is to file a complaint, is to, you know, send a copy of that complaint with a cease and desist letter. In terms of best practices, that's sort of something that's going to secure at least your right to pursue that matter going forward. And then I think beyond that, it's really sort of business as usual for the most part at the courts, because even though you're not necessarily going to be able to get a hearing or a trial date very early on, really the bulk of trademark infringement litigation takes place before trial, and the bulk of, you know, litigation proceedings take place in the discovery phase. So you will still be able to enforce your rights. You'll still be able to, you know, require the other party to respond, file an answer. If not, you know, move for default judgment. There's still a lot you can do, even though we're having more difficulty getting in front of an actual judge, you know, getting a trial date and all those things. So you can still initiate litigation and enforce your rights now without necessarily, you know, having a trial judge or a jury ready to hear the final case.
Perfect. And the final question, this was referring to a comment that was made earlier, the concept of a decorative use of a mark. Can you elaborate further on why that would not count as a use in commerce? And is there a particular test that you would recommend in identifying if a particular use is decorative or source identifying?
Oh gosh, I would recommend looking at the TVMP and at the TTAB blog, TTAB blog website for examples, but it's really a hard line to draw between ornamental and trademark use, because you know, it's all depends on how a consumer is going to perceive it. You know, if you slap a phrase across a shirt, if it just looks like a decoration, that gets more towards the ornamental side. If it's, if it happens to be Nike and has a logo, it just depends on consumer perception, and a lot of that has to do with how you're using it. But typically the more branded use, apparel use, typically what you would think of would be more like what's in your hang tag versus what's slapped across the shirt. But at least for another place you could draw the line besides ornamental use would be for, if it's a common phrase. I have seen rejections by the USPTO for common phrases or terms that can't serve as source identifiers. So there's a lot of examples in the TBMP. If you Google the TTAB blog, they have a lot of interesting cases that they highlight. I would recommend looking at those, but ultimately it just comes down to you want your mark to be perceived as this is the brand as opposed to this is a decoration.
Yeah, I think just the best preemptive strategy is, showing the best possible specimens and as many specimens that would, show that it's just more than ornamental.
Definitely.
Excellent. So that finishes up for questions. Michael, do you have any final closing thoughts?
I think that's great. Thank you so much for the listeners, all those great questions. Thank you especially to our speakers. Again, Meredith Williams, Associate Top 10 TTAB Litigator, Opposer, for 2020. Nehal, I've actually seen his software, his cloud-based trademark docketing system. It's pretty impressive. And there are any trademark prosecutors on the phone, definitely take a look at it. Thank you both for joining our call today. This is the first time we've actually had two speakers on the call and doing a webinar like this. So it's definitely interesting for me to kind of figure out how the technology works and kind of bouncing between several people and the computer screen. It's going to be an experience, but we're all trying to figure these things out as we go forward. I'd like to give a quick pitch for next week for those who are listening today and want to continue on these episodes. Next week, we're going to be going all about video depositions. How do you take them? How does the software work? How do you deal with the person who's might be 1,000 miles away from you? How do you get a court reporter to properly document the deposition? So it's going to be a pretty interesting call where we're going to go deep dive in just how to take depositions remotely. Any closing thoughts, Meredith or Nehal?
No, I mean, this is great. Thank you for organizing this. And if anyone has any follow-up questions, happy to please email me, contact me any way that you'd like.
Same here. This was a lot of fun. Definitely, we're very passionate about these issues, and it's really fun to be able to talk to sort of other folks who are knowledgeable in the area. And definitely, if anyone has any follow-up questions, feel free to follow up.
All right. Thank you both for joining speakers, and thank you, Erin, for organizing. We'll see you next week, hopefully.
Thanks, everyone.
Thanks.